I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
going to come up in federal district court
absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember, Senator Kennedy.
Okay. Do you know?
Hey everyone, welcome back to Congress Lens, where we take a deeper look at what really happens inside Congress. The moments, the questions, and the truths that often go unnoticed. Now, today's video is a must-watch. Senator John Kennedy, in classic Kennedy fashion, grills judicial nominees for the U.S. District Court of North Carolina. And let me tell you, this is one of those hearings where sharp questioning meets real-world reasoning. Kennedy isn't just asking for answers, he's testing how these potential judges think. Whether it's about constitutional law, discrimination cases, or basic courtroom principles, his goal is clear: to make sure these nominees actually understand the laws they'll be interpreting. So before we dive in, make sure to hit that subscribe button, tap the notification bell, and drop a comment below after watching the full video. I want to know if you think Kennedy was being too tough or just doing his job. All right, let's roll the clip.
I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy
Let's just start in the middle and we'll work to the end. Tell me, Mr.
Orso, yes.
Orso, I'm sorry. I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion, gender. And then I would apply the facts of that case, pursuant to
What facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then, if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if the small business owner said it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really can't see. I need to do something.
It's Mr. Bragdon.
David Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
going to come up in federal district court
absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's turn your
This is
microphone for me,
Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. Let me go back to Mr. Orso. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure. For a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the
that
same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors in it.
All right, now that you've seen it, let's talk about what just happened. Senator Kennedy once again showed why he's one of the most unfiltered and effective questioners in the Senate Judiciary Committee. His style might seem humorous or even awkward at first, but there's a strategy behind it. He doesn't just ask surface-level questions, he probes for understanding. Take the exchange with Mr. Orso, for example. Kennedy's hypothetical about a small business firing an employee for wearing a burqa wasn't random. It was a smart test to see if the nominee truly understood Title VII and the balance between religious freedom and workplace rules. Orso gave a decent response, citing discrimination law, but Kennedy kept digging. What if the customer doesn't like it? What if it's a safety issue? That's classic Kennedy, not trying to embarrass anyone, but exposing whether someone can think through the gray areas of the law. Then there was the moment with Mr. Bragdon and the question on supplemental jurisdiction. Bragdon clearly struggled, and Kennedy knew it. It's not about being mean, it's about accountability. If you're going to serve as a federal judge, you need to know the fundamentals. Thankfully, Judge Rodriguez stepped in with a clean and confident explanation, showing exactly what Kennedy wanted to see: clarity, command, and comprehension. And when Kennedy asked about constitutional amendments, injunctions, and class actions, again, he wasn't fishing for trivia. He was checking if these nominees could handle the legal basics that affect real people. A good judge isn't just about academic knowledge, it's about applying the law with precision and fairness. To me, this video proves that Kennedy's questioning style works. It cuts through the pre-rehearsed talking points and forces nominees to show whether they truly know their stuff. Whether you agree with him or not, you can't deny one thing: Senator Kennedy takes his role of vetting judges seriously. And in an era where too many hearings feel like political theater, that kind of no-nonsense approach deserves some respect. If you enjoyed this breakdown, don't forget to like this video, subscribe to Congress Lens, and comment below what you think. Was Kennedy fair, or did he go too far? I'll be reading through the comments and replying to some of your takes in the next video. Until then, stay sharp, stay curious. This is Congress Lens, bringing Congress into focus.